Attorney Prashanthi.
Hello.
Can I use my remaining STEM OPT time after my H-1B expires? I changed
Uh,
status from F1 to H1. I still have time left on my STEM OPT. Can I go back and use it if I had a year left?
no, you can't because once you file for a change of status, as per the last action rule, that change of status becomes your status. So if you want to again change back into a particular status that you were previously on, you'll have to file a change of status again and wait for it to get approved, and then you will be in that status again. Every time you request something from USCIS and it is granted, then that is your present status. Now,
So,
also, the other thing is the STEM OPT is not something that you can do in installments. It's something that you have to do at one time. And if you don't make use of it, then you've lost it.
so this is a standard question I read on a lot of Facebook groups. People still assume after they have moved from, for example, somebody had an H4 EAD, just like in this case, they moved to an H1 and they still assume because they have a plastic card or a piece of paper which still shows that there is some validity left. So can you throw some light, explain people on what happens? You just stated something called last action rule, and what happens to the previous status and the corresponding benefits like an EAD card in terms of the STEM OPT for an F1 or an H4 EAD for an H4 visa holder.
Yeah, so as I said, once you apply or request USCIS to change your status, and once that request is granted, then that becomes your new status. That is the last action rule that USCIS follows. For example, in another scenario, say you file one H-1B petition and then you file a second H-1B petition transfer, one to company A and one to company B. Then the status that you'll have is the H-1B approved or the H-1B that was filed last action rule. So the second H-1B is effectively will become your status once it gets approved. Or if you filed a H4 and then you filed a H1, your H1 would be your status once it gets approved, unless you withdraw the H1 before it gets approved. Of course, then the H4 will become your status. So this a lot of people are always confused about this last action rule and what their status is because they sometimes file multiple applications due to various reasons. So that's one thing that you need to keep in mind. Also, there's a question about, say, you're on one H1 and then you move to another H1 employer. And then you want to move back after the company A has a H1 with you, company B then gets an approval for a transfer. You work with company B for some time, then you want to move back to company A as company A has not withdrawn their H1B. This is a gray area as to, there's an old memo from USCIS which says that you can. But there are many issues with reference to this. One is that, as an employer, you're sort of required to withdraw the H1 if that employee is not working for you anymore. And you don't want to keep a H1 lying around like that because then the employee can come back and say that, it was not the offer or the employment was not withdrawn, so you owe them the pay from the beginning to now, even though they did work for you. So there are many issues with that. So I just, in that situation where, moving between different employers, I would just again file a H1B again, just so that there's no issue with, your adjustment of status when you come back, when you file a green card, and when you're filing the 485. There's no issue with reference to your status. And also, FDNS visits are a thing nowadays. And if the officer would come and visit at one of the employers and you're not there, they'll question what happened and where the employee went, and they may make a negative remark or withdraw the H1 or something like that. So it's better to just make it clean since it's a gray area and just file the H1 again.
So for employees, if an employer has not revoked the H1 and there are some other consequences like a site visit, and the employee has moved out to another employer, but then the previous employer has not revoked or withdrawn the H1. Now, what happens if there's a, I know we're dragging this topic, but then it's, something relevant here. What happens if, how is the employee affected because of an error that, let's say for a 6 months or a year, the H1B was still active from the previous employer. It was never withdrawn, and there was a site visit. Now, what happens? What is the effect on the employee? Because, it's not his fault or her fault. They're working for a new job. Now, how does that work?
The employee should not be affected in that particular situation because they're not moving back and forth from one employer to another. In my example, I was saying not to move back and forth because this might cause an additional problem because the H1B has to be withdrawn. But in the scenario where you ask your question, if the employee is not moving back and forth, has just moved from company A to company B, company A has forgot to withdraw the H1 and there's a site visit, they will maybe revoke the H1 for company A, then it doesn't matter anyway with reference to company A because the beneficiary has already moved to company B. So it should not affect their status in any way in that scenario.
Okay. Thank you for answering that question.